pieces of homework I was set yesterday. The first is OFWAT as a non-ministerial government department. We've brought along copies of Section 1A. Thank you very much. There's two documents that I'm handing up. The first is Section 1A, and the second is the clean copy of the reporting guidance for unplanned outages. The bench asked me yesterday about why it was in track changes, so this is...
Thank you very much.
That's that.
Thank you. Yes, so we had a track change version previously, didn't we?
For your note, the version that modifies to a very modest immaterial extent is at SB 11, tab 11, page 179. I'm going to go straight on, if I may, to the grounds. I'm going to just take the grounds into as shortly as I'm able. Ground 1A is a question of construction. It's dealt with in our skeleton paragraphs 26 to 53. It's addressed in the judgment, paragraphs 59 to 92. The parties agree that the learned judge set out with respect the correct test to be applied following Lambeth and O, and he cited the relevant principles in his judgment. The text for this exercise in construction we looked at extensively yesterday, so I don't need to repeat what I said on that. In terms of the natural and ordinary meaning of the words, we say the water company can make representations in order to seek an outcome which is different from the one which would apply if the performance criteria were assessed without any adjustment. So the calculation here would have resulted in NWL, Northumbrian Water, having to make a substantial underperformance payment. We can see that in practical terms in supplemental bundle tab 23, please, page 346. That's tab 23, page 346 in the supplemental bundle. This is part of a pro forma return, and in the third line down there's a row that begins water supply interruptions. It then refers to a reference number. It indicates that the unit is in hours, minutes and seconds. It indicates what the performance level was. It then says that the performance commitment was not met, because it has no in the next box. And then the outperformance or underperformance payment is indicated. And that tracks through to effectively the value of the underperformance payment that Northumbria was obliged to make for that particular commitment. And that commitment is the common commitment. 5 lines up from the bottom, there's a box that begins interruptions to supplies greater than 12 hours. That's the bespoke performance commitment number 1. And it's a performance commitment that was selected by Northumbria, and they effectively set its terms with approval from OFWAT. And then one sees under performance level actual, a figure is given. Is the performance commitment met? No. What is the consequence? And that's minus 17 million odd. Bottom of the page is the second bespoke commitment, interruptions to supply between 1 and 3 hours, and tracking across, this didn't lead to an underperformance payment, it led to an outperformance payment. So they met the performance criteria and they exceeded it, and so they got money back. That, in practical terms, was the outcome of putting the data into the system in the way I indicated yesterday. And what was then done, as I indicated yesterday, was that Northumbria made a representation to attempt to persuade OFWAT to reduce the amount of adjustment that would otherwise have to be made to its allowed revenue under condition B 12.5.
Who creates the pro forma 3A?
The pro forma form itself will be one that the regulator has effectively defined.
So that is harvesting the data that Northumbria has provided to you?
Yes.
And it's prepared before the representation is made. So they get it?
Yes. The representation was then made by Northumbria effectively to seek relief from the full financial burden of what would otherwise have been the failure to meet the performance criteria. It chose the arguments it deployed, and it no doubt selected those arguments with a view to seeking to persuade OFWAT to exercise a discretion to intervene in its cause. Those arguments that Northumbria chose to deploy were ones about allocation of risk for significant adverse events which were said to be rare. They relied upon the need for effective incentives and efficient investments, and they made submissions about the size of the adjustment. So, in other words, Northumbria chose to make representations that were not restricted to issues of performance. The CE exception left OFWAT to consider those representations and to determine, in an exercise of its regulatory judgment, whether any change should be made to what would otherwise be the adjustment of the allowed revenue, simply applying the performance criteria.
So the CE exception, was there any other basis upon which such representations could be received other than the CE exception?
Well, we'll see in a moment that companies, even if they do not meet the criteria for civil emergency, can still put in representations, and my client has a public law duty to consider them, even if they're not relevant. One must consider them. Perhaps we can go to that document now if I can find the reference to it. This comes in with...
But just to be clear, the representations that were they made under the CE exception, or were they made more generally?
Well, we can look at the submission that went in. That's in the supplemental bundle. Thank you. Tab 15. If we could start, please, at tab 14, page 221, which is the accompanying letter. So the letter came in from Northumbria, a representation for a partial exclusion of Storm Arwen impacts.
It's actually a partial exemption is what they say.
Well, they use the term interchangeably,
yeah.
it seems, throughout the terms of this document. The paragraph I'll draw to your attention is, having set out effectively the previous performance and the impact of the particular storm, they then say in the final paragraph, left unmitigated, this will result in a higher cost of capital for customers to mitigate this risk, and companies being incentivised to invest uneconomically to reduce the impact of extreme weather events. To manage these issues, OFWAT included an explicit opportunity to request an exemption in the PR19 final determination, which applies across these ODIs. That exemption allows for representations to be made where a civil emergency is triggered under the CCA 2004. OFWAT can then make an informed decision flexibly on the strength of the evidence.
Yes, I'm sorry, but just going back to my prior question, you draw attention to the first paragraph, which sets out, it is a submission, describing a submission setting out a request for a partial exemption to, as it says, the impacts of the storm last November. That looks in the context, and then the last lines on the page, the exemption allows for representations made where a civil emergency is triggered.
Yes.
It looks as if this is an appeal to the CE exemption.
Yes.
So that appears to be common ground between. In other words, this is not one of the. You say that there might be a generalised ability simply to come to you and say something's up.
This was that possibility exists. I was dealing with the is it possible?
But actually, this is a CE exemption submission which they are perfectly entitled to make.
Yes.
And we're now seeing what it contained.
Yes. And then the fully fledged submission then begins, as Mel and Friend indicated, at tab 15, page 224. And one sees, for example, page 227, recital 8, the overall impact of Storm Arwen, it said, met the criteria for a civil emergency. They obtained independent legal analysis from Tuppus Law, which told them that they could make an application for the exemption, make a request for the exemption. OFWAT allowed companies to make an application to exclude interruptions caused by civil emergencies. The storm therefore appears to us to represent precisely the event OFWAT must have included the exemption in the PC4. So they are invoking expressly the CE exemption, and their submissions are then tailored, no doubt, to what they think will tug at the heartstrings of their regulator. Page 237, for example, maintaining the right incentives to protect consumers. 239, implications for pricing, and so on. One can click through it. And 243, they suggest a partial exemption, having taken into account fault. It's probably worth me just, while I have the document open, dealing with a point I'll develop later. If we look at page 234, the alternative proposed ODI penalty that Northumbria advance is based on excluding from the exclusion, as it were, accepting from the exclusion, certain impacts which they identify as being something they could have done better at. So 100% of ODI impact in one area where the prevention of generator failure could have eliminated all outages, etc. So they've then, in broad generic terms, identified certain impacts which they say they would not meet the fault criteria that they've chosen to set for the application of the exemption. But as I indicated yesterday, it's not part of our case. There is a fault, no fault distinction on the face of this particular piece of reporting guidance.
But since it's a discretion to apply, they may have decided that it wouldn't be morally right or commercially not a good thing to do so. That in itself doesn't prove anything, does it?
Yes, I mean, once we're in the territory of discretion, a well-advised regulated entity would obviously seek to either excuse or remove from consideration those instances where it was at fault for not having responded appropriately and therefore there was a failure to mitigate, as I indicated yesterday. That would be a sensible course of action with respect. But it's predicated upon an exercise of discretion. It's not anything that is baked into the test itself. Right, that's, I hope, dealt with that question. I don't need to come back to that document happily later on. So, what we say is the CE exception leaves off what to consider the representations that are made and to work out, pursuant to condition B 12.5, what adjustment of the allowed revenue should be permitted as a result. The draft determination and the final determination in this case, therefore, both were aimed at and addressed the specific representations that have been made to the regulator. We say that the use of the expression on the basis of, in the test, on the basis of the civil emergency, does not imply a causation test alone with an automatic entitlement. The representation has to be based on the fact of the civil emergency, but there's no guarantee that an exception will be granted. And with respect, we see no basis in that test for the fault, no fault distinction, but I accept that that could be a relevant consideration, will be a relevant consideration at the discretionary stage. The analysis I've just shown you seems to select certain inputs for exclusion, but we haven't identified a logical basis upon which those rather than others have been chosen. My learned friend says, well, we've never contested that choice. We haven't engaged with that choice because we haven't needed to. Because ultimately, whilst it was a relevant consideration that they were seeking to pay a penalty of only 3 million, nonetheless, the basis upon which my client took their decision in due course was not predicated on a strict analysis of fault, no fault. It was, they were looking at what were the expected parameters of return for a regulated entity, and for a particular year, would the impact of the adjustment mean that the expected return fell out with the parameters that were readily identifiable in advance. And that then triggered the decision for the risk to be split equally between the water company and its customers.
Well, just putting this document in its sequence, your first reply was no. And then there were further submissions. Was that the sequence of events?
The first reply, I'm sorry, my lord.
Your first reply was no.
To
No, nothing. You rejected.
Oh, I see. Sorry.
Yeah,
Yes.
I mean, I'm just. I
The
mean,
draft
I think we've been.
determination.
The draft determination, yes.
Yes. So This is at the stage before you've given your draft determination, which was different from your final determination.
The submission went in.
Yes.
The draft determination came back and said we're not moved to make any change to the adjustment. And then a more detailed submission was deployed. I wasn't planning on going through that, but for your notes.
No, but just to give us the page references where they're to be found.
That's supplemental bundle tab 20, page 315. It's framed as a consultation response, but that is effectively Northumbria's submission as to why the draft determination should not be followed.
Sorry, the reference for the draft determination is where?
The draft determination itself
Tab
is
18.
Tab 18, thank you, my lord. Page 297.
Thank you. All right.
The draft determination and the final determination are accurately summarised in the judge's judgment, so I wasn't planning to weary the court by going through the core document. Now, in fact, dealing with the question of fault, the supply interruption performance commitments do have a stance on fault, because as we saw yesterday in the reporting guidance, all supply interruptions have to be reported regardless of fault. It covers planned, unplanned, supply interruptions caused by third parties, regardless of any position of whether or not it's the water company's fault that there is a supply interruption. So that is the basic policy position, i.e. you have to report all supply interruptions and there are no exclusions. Now, in terms of relevant context, so that's the submissions I wish to make on the natural and ordinary meanings of the words. Moving on to relevant context, what we saw yesterday, and I don't propose to go back through, were examples of different wording being used within the reporting guidance for different performance commitments, where it was intended for an exclusion to operate mechanistically. And that, as we went through, either involves data not being submitted into the form, or data being submitted into the form but then excluded from the calculation. And I gave the court two examples of that. There are, we say, some other safety valves that are built into the regulatory landscape. So we have collars and caps. Could we look, please, in supplemental bundle 13, page 210. We did look at this yesterday. I just wanted to draw to your attention one or 2 points. 210 is the common performance criterion for water supply interruptions. My learned friend went through the reasons why, the basis for its calculation. My Lord Justice Lewis pointed out that specific exclusions were none, and that is the passage we rely upon. There are no exclusions from this built into the performance criterion.
What does that mean? No exclusion from reporting?
Yes.
It doesn't mean no exclusion from not being able to adjust?
Well, it's obviously against the overlay of the CE exception, but the CE exception does not operate an exclusion. It operates as invocation of a discretionary power.
No, I understand that's your case, but is that because of these words? These words, no. You don't seem to rely on this as a reason why it's not an absolute mechanistic exception, or do you rely on this?
In my respectful submission, if this were an automatic entitlement that removed the requirement to report on civil emergency caused supply interruptions, the specific exclusion would have been listed there. At page 212, we see the collars and caps. What that produces is both a performance commitment level and then an enhanced and a standard collar and an enhanced and a standard outperformance cap. So it's a calibrated response to meeting, exceeding or failing to meet the performance commitment level that's been set. Learned friend's quite right to say that over time you're meant to get better at things, but the collars and caps move with it. And we do say that provides a calibrated response to underperformance, for example, which operates as a safety net. The same applies to the other bespoke commitments in terms of the overall structure, but tellingly they don't contain any collars or caps. The first is at page 215, interruptions to supply greater than 12 hours. Specific exclusions halfway down the page, none. That's the overall structure. But then, and bearing in mind this is a performance commitment that has been proposed by the company itself. The company has calibrated what it says it is prepared to meet. It has chosen the performance commitment level, and it has chosen not to set collars and caps at page 216. At page 218 is the second bespoke supply interruption performance criterion. This one was met, as we've seen. But again, in terms of specific exclusions, there is text. It says interruptions above 3 hours are excluded as they are reported through the common measure. So it ties in with the 3-hour common supply interruption performance criterion.
That makes me think it's exclusions from reporting rather than anything to do with use of the data.
Well, that's right. Yes, I'm sorry. This is about reporting the performance.
Yeah. So the fact that there's a specific exclusion in all these three things doesn't. I thought you were saying if it had been an absolute entitlement to be able to claim back, it would have said so in specific exclusions. But if this is just about reporting the data, then it doesn't tell you anything about the exception.
I think, with respect, Lord, my Lord, that's absolutely right.
Oh, right, well then, that's not what I've written down. Give me a minute.
Well, there are two separate questions, if I can put it this way. Is the effect of the CE exception that you exclude the data automatically? Answer no. Does that mean that our construction of the CE exception must follow? Answer, not necessarily.
Yeah.
Because one could have a construction of the CE exception which somehow granted an exemption rather than an exclusion that was automatic in effect.
It would be an exemption from use of information, not an exemption from reporting.
It would be an exemption from including the full ambit of the data into an adjustment.
Yeah.
I accept that logically that follows with respect. But when we do deal with specific exclusions as such, I mean, I suppose that there's a risk here of semantics becoming too determinative and the difference between exemption and exclusion mattering too much. But we do rely upon the fact that this is not an exclusion. And so when my learned friend said yesterday, it's an exemption from a policy of no exclusions, therefore it's an exclusion, the answer to that is no, it's not. If it were an exclusion from an obligation to report, it would have been included here. Just to complete the analysis, page 219, collars and caps, none set. So we say that the complaint about underperformance therefore needs to be seen in the context of the clear, uncontestable fact that the performance commitments were not met by this water company for the year in question. And whilst below it was said that the penalty was not proportionate, and that had to be obviously seen in the context of an operating profit for 2022 of 174 million in the water company, that allegation is no longer pursued. The history of drafting, we say, with respect, doesn't show any different meaning. If one could look, please, in supplemental bundle, tab 6, page 128. This is part of the UK water industry report. At the bottom of the page, exclusions. It said a key area of simplification. This is from the consultants who drafted the report that was then put to the steering group who recommended its approval. A key area of simplification was the reduction or elimination of circumstances which would be acceptable as exclusions. Exclusions are to be kept to a minimum and shall be consistent with the reasonable expectations of an affected customer. So that fits into the general policy framework that OFWAT was advancing post PR14 of a switch to outcomes-based regulation where companies had to meet the commitments set of them. And my learned friend also relies on the previous reporting standards from DG3. For my lords and my ladies note, that's supplemental bundle tab 5, page 107. But that operated a different regime. My learned friend also said that the water report that we've just looked at was drafting during the currency of DG3, but in fact, by then, PR14 had been brought in. So we were in the regime of price control that was established by PR14 by 2017, which was when the UK Water Industry Report was published. Now, the exclusion, for the sake of argument, we say DG3 has therefore no meaningful bearing on the proper construction of a different regime 2 price control periods later. But even if one were to look at the text, it's a limited exclusion for third-party damage, which is narrow and has to meet the requirement of, for example, a third party causing the damage to the mains or other equipment. That's all I wish to say on the relevant context to the drafting. In terms of policy considerations...
Before you do that, you hinted yesterday that there was an appendix which showed that there were areas of disagreement at the stage of the Water Industry Report.
Yes.
Have you shown us that?
It's not in the bundle, I'm afraid.
Oh, right.
We've got copies and we'll show it to you in reply.
Okay.
I think it doesn't substantiate what my learned friend says at all.
Well, if you can produce it to the court, I can make submissions on it beforehand. I don't have a chance to make submissions on it. It wasn't included in the bundle. We asked for various things to be included in the bundle, and there was a spat about it, which I'm not going to.
Okay, but you're not making any submissions on it?
Didn't include Appendix B, the completeness. So my learned friend is wrong in relation to that. You can hand those up as well to you. It was in the bundle below.
It was in the bundle below.
It was in the bundle below.
I've said it was in the bundle below.
Yeah.
Let's not worry about that.
No.
Thank you.
This
Thank you very much.
looks as though it's more than Appendix B, but if we go, please, to page 361.
The reason it's more than Appendix B is because you'll see the relevant contents of Appendix B.
Yes, don't worry. Let's
Relates to
just...
sewer flooding. So we've added the sewer flooding bits to which it relates, so you can understand.
Yes, it's at the risk of generating more heat than light. At page 361, there's then a list of components of the methodology which has been discussed but not progressed.
What part of this is of any interest to us? Last page, 364, it's severe weather.
Yes, thank you.
And my lord will see the heading sewer flooding.
So there was a debate in the group as to the impact of severe weather. True it is that it's being dealt with here under sewer flooding, but there was, my understanding was the position advanced below was that OFWAT's approach to severe weather was that companies should become more resilient to severe weather, and on that basis there is a reference in the judgment, which again is not found in the bundle. I think it's it's at page 83 of the core bundle. It's referring to the background that was set out in the final determination of PR19, which was the periodic review that we're dealing with. And one sees at page 83, top of the page, it's important that performance commitments are transparent so that we, along with customers, stakeholders, other regulators and companies, can understand, compare and monitor performance. This is achieved by setting performance commitments that are clear, unambiguous, complete and concise with no inappropriate exemptions. In setting performance commitments for each company, we see a limited role for exclusions. For example, while weather is a factor outside company control, the response to managing the risks and uncertainty associated with weather and the operational response to a severe weather incident are within company's control. So it was my client's position, certainly from 2017 onwards, that we wouldn't have exclusions for severe weather incidents because they were a matter that the companies could control. Can I please come on now to policy considerations? We say that the relevant policy context here is the one that's apparent on the face of the reporting guidance itself, which is a general policy of no exclusions and a refusal to permit exclusions for bespoke performance commitments. as I've just taken the court to, our repeated stance has been that it's for companies to manage the risk of severe adverse weather and develop resilient networks. It's also been our repeated stance that companies are better able to assess and respond to the risk than consumers are. So what we saw with PR14 was a switch to outcomes-based regulation and a desire on the part of the regulator to incentivise long-term operational resilience. That policy was then further developed in PR19. Could we please briefly delve into the PR19 methodology? It's Supplemental Bundle Tab 8, page 147. Bundle 8, Tab 8, page 147, Supplemental Bundle. This has, in the third paragraph, excuse me, third paragraph, a reference to setting more stretching commitments for water companies to meet their customers. And it says at the final paragraph of the page, our approach to outcomes supports the key themes of PR19. Our approach focuses on ensuring companies set stretching commitments for all aspects of customer service. We are promoting long-term operational resilience through the common performance commitments.
This all seems fairly vanilla stuff, isn't it? I mean, haven't we been through this?
What this shows is what the policy ambition.
Well, yes, I mean, obviously, better water services don't break down. I mean,
in terms of slightly more specific steering, we see at page 157 confirmation that there should be no or very few exemptions included in the definition of bespoke performance commitments.
yes, well, I think all of these general points we've got. We're going over again matters that we well understand your client's position.
Well, my lord, I'll move on. Just for your note, the final determination for the common performance commitments at Supplemental Bundle Tab 12, page 198, also confirmed that there was a limited role for exclusions in the ODI regime.
Question here is this one of the limited ones, though? It doesn't answer the question, does it?
No. But when one is searching for policy context, if that is the general policy set, then one starts the construction process with that well in mind, in my respect.
Yeah, well, one also starts the construction process with well in mind that it was thought that there ought to be an exception possibility. So that doesn't really take us very far.
Can I please then come on to deal with the CMA redetermination, which my learned friend has relied upon to a limited extent. Now, we have said, well, this is something, if you objected to the terms of the CE exception, that's something you could have raised with OFWAT, and with the CMA, and you didn't. My learned friend's response to that was they hadn't understood the CE exception to be granted in the way that they say, the way we now put it. Now that's in fact belied by the judge's findings at paragraphs 41 to 46. If we could look at those, please. That's Core Bundle, tab 6, page 104. And if I could invite the court, please, to cast an eye over 41 to 46, because the learned judge there rejects the suggestion that Northumbria had understood that it was an automatic entitlement and there was no discretion.
And what's the relevance of that?
Well, it's a responsive point to my learned friend's submission yesterday, that the reason we didn't challenge before the CMA this drafting was because we had understood it conferred an automatic entitlement rather than the discretion. And the response to that has been determined by the judge. That isn't, in fact, what you understood.
I think this is the sort of point that has, at least to my mind, very limited leverage either way.
I will move on. It's a responsive point. I don't want to respond to a bad point.
No, I'm not saying it's a bad point. I'm just saying that, obviously, the parties will pick over every possible unit of information that might shine some light. It just seems to me that whoever or whether there's any light in this, it's pretty dim in terms of helping us with the call.
It seems to be the wrong way round. If the system is no exceptions, and that depends on interpretation, then they should have appealed it.
Yes.
If the system was exceptions, then they're fine, and that's the point of determining. But to argue what it means by what I'd like to happen if I win or lose seems to me to be Alice in Wonderland.
Well, I respectfully agree.
Yeah.
And this is why it's a responsive point, not
Right.
a major plank in my argument. Unfortunately, I'm now dealing largely with responsive points.
Right,
And-
okay, so we mustn't shout at you.
Well, there were quite a few bullets fired at me yesterday, and I'm simply trying to find the Kevlar to meet any
Yes.
that might hit the body. A further point in the skeleton, I'm not going to develop it, is that somehow the judge was wrong to reject Mr. Beaver's evidence. And in the light of the judicial intervention just a moment ago, I'm not going to develop that point. Safe to say that the defendant's evidence was to the contrary, and Saphir, which my learned friend relies upon, says if the defendant's evidence is not cross-examined either, then the general approach is to accept the defendant's evidence. Again, not an area that is terribly illuminating in terms of the answers the court must reach. Next point was the alleged impact on investment. I think I can take this very shortly. If we're right in the construction, then the company should have been pricing for that. It should have been pricing for the assumption that even in severe adverse weather, it would have to pick up the bill for any water supply interruptions. And as an efficient company, as the judge indicated, it should have been taking that into account when it was determining its approach to investment. As a matter of fact, there is quite a detailed regulated procedure whereby expenditure is allowed for capital investment. There was a process, for example, for providing base expenditure, for routine year-on-year costs, for maintaining long-term capability of assets, for improving efficiency and so on. What OFWAT does not do is tell a company what to spend its money on. So we don't say to the company, you need to have so many snow sweepers, you need to have so many backup generators. That's not a matter for us. What we do through the exercise of regulation is allow the allowed revenue in part to reflect capital expenditure requirements. And that is appropriate in circumstances where these are regional monopolies under a price control regime, that there is an element of regulatory control over the funding. I think that's all I need to say on the investment argument. In terms of the inefficient investment argument, the short answer to this is it was again dealt with by the judge. Core bundle, page 106, paragraphs 50 to 56. I can invite the court just to, again, to cast an eye over those paragraphs, where the learned judge below rejected the suggestion that our construction would necessarily lead to inefficient investment by the water company. He concluded to the contrary, that the evidence did not show that that was likely. Paragraph 54. Northumbria's own conduct supports what I have said. Northumbria presents itself without dispute as an efficient water company. There was no suggestion that it had invested inefficiently before Storm Arwen, even though, as I have shown, it believed that a CE exception discretion existed. In such circumstances, I do not follow how Northumbria can maintain an efficient water company would invest inefficiently if a CE exception discretion exists. And he then supported our reasoning and our assessment that investment would not be inefficiently too high if our construction of the CE exception were right. In order to challenge those findings, the learned friend, of course, has to meet the standard test set by Farge and Chobani, the Greek yogurt case, that this course is very familiar with. Right, next point is, it's said this, our decision reflects policy, but they've been stripped of a right of redetermination. And I have two principal responses to that. The first is that our final determination is not a statement of a performance commitment, nor is it a policy statement about the terms of any exclusion or exception. It is a response to a representation that has been made to it by a water company. On Northumbria's own case, my client can expect to receive such a representation once every 30 years. I don't have the actuarial expertise my London friends deployed, but if that's right, then what we're dealing with is hardly a year-on-year policy issue. My London friend, with respect, is also wrong to suggest that our construction stymies the CMA's role or effective judicial protection. We've cited extensive case law in our skeleton to support the proposition that judicial review is capable of moulding to meet the challenges that are set of it. The fact that my learned friend didn't succeed in his rationality challenge doesn't mean that that process was ineffective, because as you've seen from the very detailed treatment on ground 3, and you've been spared the 4-lever arch files that we had to plough through below for the documentary evidence, the judge rolled up his sleeves and got his hands dirty on analysing proportionality arguments, rationality arguments, and everything else. The fact that the challenge was rejected does not show the ineffectiveness of judicial review in dealing with this type of challenge.
It doesn't matter anyway, because they may have been mistaken, and I know what you say about that, as to whether there was or wasn't an automatic exception. But either that's part of the structure, and if they thought it was a discretion and didn't want a discretion, they could have appealed that as part of the appeal against the performance commitment. Or if they made a mistake about it, well, it's not their fault.
And the licence conditions themselves, which contain the demarcation between a CMA redetermination for interim determinations versus not having a CMA redetermination for in-period adjustment calculations, is part and parcel of the licence conditions. And it's a point I made below, which the judges accepted, that these licensing conditions had to be accepted by the water company, or they could have challenged them. But they didn't challenge them, they simply accepted them. So, if my learned friend's right, and he is, that there is no CMA redetermination for an in-period adjustment of allowed revenue under condition B12, that would have been evident on its face at the point that the water company nonetheless chose to accept those licence conditions as part of its authorisation for exercising water undertaking services.
But am I right in thinking that because the licence refers to a performance commitment, and if that performance commitment is absolute and doesn't permit of an automatic exclusion, they could at the outset have appealed that?
Yes, that could have been kept within the scope of a redetermination request.
Yeah, okay.
There was in fact a redetermination here, and the CMA did in fact redetermine the price control regime. So strictly speaking, the reporting guidance, the performance commitments and everything else is the product of the CMA redetermination. It's not an appeal on the merits, it's a wholesale redetermination. So the CMA ultimately is responsible for saying this is what the price control regime will look like.
Yep.
Now, can I briefly deal with condition B14.2 and the adverse events, adverse circumstances requirement. That's in supplemental bundle B24. And if we could cut to the chase, please, at page 381. It's got quite a lot of detail, but essentially if there has been a relevant change in circumstance, see page 373, then it's open to a water company to seek an adjustment if certain materiality criteria are met. So it has to be a substantial adverse effect that has a material impact on revenue, varies between 10% and 20% impact. One sees at 381, one of the issues that the authority, i.e. OFWAT, will be asked to determine is whether any circumstances occurred which has or will have a substantial adverse effect on the appointed business and its assets, profits or losses, etc., or a substantial favourable effect on the appointed business. Now, condition B14 is framed as an avenue for the water company to raise this. What we then see at page 382, paragraph 15.1, is in the case of a notified item or where any relevant change of circumstances occurred or is to occur, OFWAT may, having been given notice to the water company specifying the notified item, notify it of its intention to do so no later than, and then some dates are set out. And we then see over the page, at the top of page 383, in the case of subparagraph 14.3, which is the paragraph I've just read about substantial adverse or substantial favourable effect, OFWAT shall give notice to the appointee of its intention to determine the questions set out in subparagraphs 14.31b and 2. Now, the consequence of that is there is the facility for OFWAT to notify the water company of its intention to make an adjustment because of a substantial favourable effect on the water company, which obviously, of course, the water company wouldn't seek to refer itself because it would be acting against its own interests to refer itself having done better than it should have done. So you do have this position. It is based on a materiality percentage of either 10 or 20%, depending on the circumstance. And this is subject to a CMA redetermination. And the reality is that the drafting of these conditions reflects, in essence, an assessment by the drafter of the material impact or lack of impact of certain situations arising. And the application of the performance criteria and the consequential adjustment year on year was not considered to fall within that category. Now, Part 3A, this Part 3A that deals with in-period adjustments for performance measure adjustments, was inserted following a licence modification process. There was a consultation on those changes, and OFWAT indicated that they did not think lower value and more routine decisions under P12 should merit a full CMA redetermination. That's all I wish to say, unless the court has any questions for me on it, on the lack of effective remedy, judicial review versus CMA point. I then have some miscellaneous sweep-up points. Firstly, the position of other regulators. This was dealt with in the final determination for your note. Core bundle, tab 14, page 312 to 313. And it's dealt with in Ms Armstrong's evidence, paragraph 76, which is supplemental bundle, tab 3, page 84. Different regulators have taken different approaches. The learned judge below thought he couldn't attribute a great deal of significance to that. Ofgem have taken one approach. The National Rail Regulator has taken another approach. OFWAT has taken a different approach. I would only add, for the sake of completeness, that whilst my learned friend, I think, relies on Ofgem and said effectively that the DNOs had a more favourable regime, that's the electricity operators. In fact, Ofgem is changing its approach. We don't have the Ofgem document in the bundle for the court, but if you'd be kind enough, please, to look at page, core bundle, tab 11, page 201. This is part of Ofwat's skeleton before the High Court. And one sees in footnote 6 at the bottom a reference with hyperlink references to changing policy from Ofgem following Storm Arwen, so that electricity companies are better prepared for extreme events. The report from Ofgem stated, we've put tough new rules in place to make sure network companies are prepared better for severe weather. So again, it's something of a straw in the wind, but I wanted to cover it off.
Or a straw in a teacup.
Maybe that'd be true as well, my lord.
An exceptional weather.
The good news is I'm rattling through my points, so I will be finished well ahead of 12 o'clock. My learned friends next point that I need to address is somehow that there will be an uncertain application of the CE exception. The CE exception is an exception. The ordinary rule is that supply interruptions count for performance criteria purposes, and there is a policy of no exclusions. What the CE exception does, and we say it's procedurally fair, is allow representations to be made in the exceptional circumstances of a civil emergency for a different treatment to be given to a water company that is making the representations. Those representations are made, a draft determination is made. That draft determination is subject to consultation in the way that OFWAT subjects, I think, almost all of its draft determinations to general consultation amongst stakeholders. This isn't a bespoke consultation process specifically for the CE exception. And the draft determination and the final determinations are published on the website so everyone can see them, and stakeholders are invited to make representations on draft determinations. There are a limited number of players in this market, 17, who are subject to price control restrictions, and they can make submissions on draft determinations if so advised. There is a point taken in writing but not argued orally, which is the sideshow argument. Somehow, my learned friend seeks to suggest that my client thought that the fact of a civil emergency was something of a sideshow. With respect, that's not right. Could I refer you, please, to the document? It's Supplemental Bundle, tab 16, 247. This is part of a meeting that was considering a number of things. It's an internal note of that meeting. The position on Northumbria is dealt with at the bottom of the page, where it says NES made its case on 2 of the 3 PCs. That's because they didn't have an underperformance outcome for the third PC, which is the spoke one. Provided evidence of storm R when they provided calculations and subtracted figures where they could have done better. So that's summarising it. We then see at the top of page 248 some internal analysis of the submission and some points made. And then, halfway down page 248, it moves on to South East Water. And the comment that my learned friend has sought to draw to the attention of this court in writing is the one at the bottom of that section dealing with South East Water, where it says CCA, i.e. the Civil Contingencies Act, is important but a bit of a sideshow, given that with Section 2 something so out of the norm indicative, but if it's not there does not mean that we cannot look into it. That's a rather truncated sentence, but the reason why the 2004 Act was something of a sideshow was because the storms that were being invoked by South East Water were not civil emergencies. So the civil emergency regime did not apply to South East Water, and therefore the CE exception was not going to be applicable. What that truncated sentence indicates is that my client was nonetheless looking at the representation that had been made and considering, conformably with its Section 2 duties, whether or not there was something that should be done about it. Now, South East Water had essentially prayed in aid the civil emergency, but it wasn't a civil emergency in fact. So they were seeking to rely on, my understanding is they were seeking to rely on it, but we were looking at the representations that were made in the round. Unless the court has any further questions for me, that's all I propose to say on ground 1A.
Yes, thank you.
Ground 1B. This is dealt with in our skeleton paragraphs 54 to 59. It's dealt with by the learned judge in 2 places. Firstly, paragraphs 74 to 76, and then secondly, as part of ground 3, actually, paragraphs 101 to 102.
So what are your skeleton references? I missed the paragraphs.
54 to 59.
Yes, sorry about that, yeah.
Now, we respectfully suggest that the judge's reasoning on this cannot be faulted. Condition B 12.7 does not state that it's only performance which must be considered, but understandably, because it's a in-period adjustment for performance, performance will be the central focus of the analysis. And the adjustment will usually be reflecting whether or not performance has exceeded or underperformed against the performance criteria that have been set. So the primary guidance for the adjustment will necessarily be the performance criteria and the outcome. But the learned judge was, with respect, right at paragraph 74, his judgment. This is at page starts at the bottom, page 115 of the core bundle, tab 6, where the learned judge says, echoing submission I've advanced before your lordships and your ladyship, Ofwat is able to relieve a water company of an automatic price reduction affected by the performance commitments for underperformance. Understood in this way, if following a representation, Ofwat could relieve a water company by reference only to its performance of supply interruption performance commitments relating to a civil emergency, it's difficult to conceive how Ofwat could ever give such relief, because the whole reason for the representation is that there has been underperformance. In other words, if it's right that all you can consider is performance, then my learned friend ends up in a substantially worse position. Now, I need to make clear, for the avoidance of any doubt, that we're not suggesting, and we stand by the final determination we've made, we're not suggesting that we would go back to the draft determination and not let them have anything. But the reality is that the logic of my learned friend's position supports the draft determination. We say it would be supportable in any event, but in the exercise of our discretion, we have they tugged at our
depends on what your definition of performance is. I mean, I don't understand this particular point. I mean, obviously, if you narrowly describe performance as being what comes out at the end of the calculation, then that's a sterile exercise. But actually, what I presumed is being meant is how well did we do?
That's exactly our case.
And not just how well did we do in the storm, but how well do we do generally? And those, I think, are things that you do accept can be taken into account in the exercise of your discretion. So I mean, it just seemed to me to be a bit of a straw man that the judge was shooting at that point.
That's the argument that was presented below orally, from recollection. It was only September, so even my memory stretches back that far. Was that there was the automatic entitlement fed in through condition B12.7 to mean that B12.5 could only be exercised to give you whatever the result was. And it was because the CE exception provided an automatic exclusion of data from the reporting requirement that it fed back into the B12.5 process. Now, the stance that's now adopted is obviously the more expansive interpretation of B12.7. But my short point remains, even on that expansive case, there is nothing in B12.5 that says that it's only the considerations in B12.7.
No, I perfectly understand that argument, but I just thought paragraph 74.
Well, I think that if I can put it this way, the learned judge below was dealing with a more dirigiste interpretation of the conditions than perhaps this court has been treated to. But again, I don't wish to add more heat than light, and in a sense it's irrelevant what the archaeology was. I'm seeking to defend the judge's position on this. Where we therefore end up is, if one looks at conditions 9.3 and 9.4, which again is going to be in supplementary bundle tab 24. Page 358, supplemental bundle tab 24, page 358. This is dealing with the periodic review of the appointed business and setting the price control as a whole. We see that there is a specific direction to exercise that power in the light of the principles which apply by virtue of Part 1 of the Water Industry Act 1991. And so when setting the periodic review and the price control for a 5-year period, there is an express direction to take into account the Section 2 duties, because they are within Part 1. And we say it necessarily follows that when one is dealing with an in-period adjustment to the outcome of that process, then it logically follows that the Section 2 duties are going to apply as well. And even if that weren't an appropriate construction for conditions, it's what must follow, because Parliament has chosen to impose those Section 2 duties on this regulator.
Yes.
It does actually say in Section 11, I think, provisions under this Act, not under this licence, but you say it's the same thing. The licence is done under the Act and it's just a shorthand, presumably.
The licence conditions are the lawful conditions imposed as an authorisation to carry out services regulated by the Act.
Yeah.
Now, we say that our construction of a discretion on OFWAT when dealing with the representations made under the CE exception is consistent with the broad textured wording of condition B12.5. And what has to be made is an overall determination of the extent to which the performance commitments have been met for a given in-period determination and what the consequential adjustment to allowed revenue should be. So the ultimate aim of condition B12.5 is to produce a figure for adjusted revenue which reflects performance but is not constrained solely to reflect performance, whether that's the narrow or the wider definition of what performance should be. And when the judge says at paragraph 76 through to 78 that process will necessarily have to take into account the Section 2 duties, he's simply reflecting what Parliament has said this regulator must do when exercising its powers, full stop.
Could you summarise for us what considerations did you take into account when you reached your determination?
They are summarised in the learned judge's judgment when he summarises what the final determination was. It's the quickest way of dealing with it. It starts at page 101 in the core bundle and then goes on for a few pages through to...
well, I was trying to avoid having to read a few pages.
Yes.
What is your summary of the considerations that you took into account when...
The considerations we took into account were that we had a general policy of no exclusions, that we expected water companies to meet their performance commitments, that in those circumstances it was appropriate to start from the premise...
Well, I'm wondering, can we do this in bullet points? Right, you've got a no exclusions policy.
No exclusion policy. Ordinarily, that would mean that the full impact of underperformance would be visited upon you. But having looked at the calculations over a 5-year period, the impact of that on the company would be within anticipated parameters of performance. But for a given year, it was recognised that the impact was material and significant. And on that basis, a departure from the draft determination position was appropriate. And in the exercise of her regulatory judgment, applying by analogy other areas of the treatment of the regulated entity where risk is shared between the consumer and the water company, a 50-50 split.
Right, so
was appropriate.
We're dealing here with the exercise of the discretion, which in the end was exercised on the basis of the highest possible level considerations. Nothing necessarily wrong with that, but I'm just seeking to identify what it was. So it wasn't that, as it were, you went down a checklist of that are sometimes found in relation to the exercise of discretions. It wasn't that it was particularly this measured against a bit of that and something of the other. It was actually a very high-level global assessment of the situation, taking into account everything that you knew and had been urged upon you.
It was responding to the representations that were made to the regulator.
Well, I understand that we've looked and you've helped us with what the matters that were urged upon you were, which were a variety of factors that were both general and specific. But in terms of the way in which you responded, you've given us the summary of it.
Yes.
It doesn't go beyond that, as I understand.
No. I mean, there's some helpful evidence from Miss Armstrong in her witness statement, which I'm sure the court will read in due course, where she identifies the particular factors that persuaded her to depart from the draft determination approach. But in essence, my lord's absolutely right that it wasn't, well, we agree with you that there was a supply interruption for that period for that area, but not for this other area, because ultimately the fact of underperformance was the fact. And the consequence of that fact of underperformance would ordinarily be that there were no exclusions and you paid the full whack. So one necessarily had to depart from performance-related criteria in order to have any movement of the default position. And therefore, when what is being urged upon us is a movement away from the default position for specific factors that are non-performance related, we were necessarily dealing with non-performance related issues.
And the impression I get is you looked at the impact on the company in financial terms and you asked yourself, is this outside the range of risk that we expected them to bear?
Yes.
Not for 5 years, but you were very soft-hearted, and for 1 year you said, oh, we'll let you have some money back.
Yes. I wouldn't necessarily endorse soft-hearted, but...
No, I don't think it's common ground that you have a heart.
We're a body corporate established by statute. I very much hope we don't.
But it is essentially an assessment of the financial impact by reference to your perception of the risk that they were supposed to bear.
Yes, that's the key factor. If one had to alight on one key factor, I respectfully agree that that was the key factor. Right. More generally, given the broad textured terms of condition B12.5, the relevant considerations that a decision maker takes into account are ones which are for the decision maker. See the DSD case, Divisional Court, Sir Brian Leveson, paragraphs 137 to 141. It's in our skeleton. It's well known to the court. That's Bundle of Authority 16, page 996. And that selection of considerations is only reviewable on rationality grounds. But here, none of that really matters, because this is actually a question of construction, and ground 1B is an offshoot of the core construction issue under 1A. And so, ultimately, if Malone Friend's right that the only thing we consider was performance, however one defines that in condition 12.7, then that isn't what was done. But I would emphasise that the reason that wasn't done was because the representations that were made to us were not performance-related representations. For a large part, they were extraneous. They were related to inefficient investment, the impact on consumers from inefficient investment, and so on. There were a panoply of representations that were made, some of which were, well, we performed well in the past, and there was a reason why we didn't perform well this time round, and we've excluded stuff that was our fault. But the representations went far further than that, and you have my submission that if it was simply pure performance, then that wouldn't have helped. Now, in terms of the risk of uncertainty that Malone Friend seemed to press upon the court quite heavily, a once in a 30-year exercise of discretion is hardly the stuff of routine and consistent decision-making by different persons within a regulatory or legal ambit where one could expect a greater degree of certainty than here. What we do have is a provision for draft determinations to be followed by representations that then lead to a final determination, and that is procedurally fair. We have looked at the representations that were made, and it was open to the company to select whatever representations it wanted to make. The primary focus of the exercise, as I've indicated, will naturally be on the fact of performance and the extent to which it's met. But it's the exceptional nature of the civil emergency that then triggers the ability to make representations. So that is not, we respectfully suggest, a departure from the golden wand to the crooked cord of discretion. It is simply the vesting of a power in the water company to make a representation if so advised, and for a regulated entity to respond to it, a regulator to respond to it. There's no substantial risk of OFWAT depriving a water company, for example, of an outperformance payment, applying its Section 2 duties. So this isn't a case where Northumbria can sensibly suggest that my client would strip it of outperformance reward if it exceeds its performance criteria. And if a regulator were to act irrationally, as the judge found, or the judge found that there was no risk of a regulator acting irrationally and refusing to apply the appropriate criteria, even though Section 2 duties overlaid that discretion. And of course, if a regulator acts irrationally, then the administrative court will call it to account. My learned friend made a submission below. The judge records, I think at paragraph 78, that it was shocking to water companies that a regulator would comply with its Section 2 duties when exercising a discretion. We respectfully suggest it would be shocking if it didn't. Ground 2. This is addressed at paragraph 60 to 69 of our skeleton, and it was addressed in the judgment at paragraphs 93 to 100. This isn't a case of unbounded discretion because the Section 2 duties are detailed and show the factors we have to take into account. The general policy set by OFWAT was that there should be no exclusions, but with a possible exception to be granted if the CE criterion were met. Once representations are made, we have a duty to consider them in any event. You've got my primary submission that the deployment of a detailed policy here was not practicable. The merits of deploying a policy is also highly debatable, given both the number and extent of civil emergencies it would have to cover for 17 different regulated entities under the price control. The alternative would be to have such a short statement of general principle as to be virtually meaningless. As a matter of law, we respectfully suggest it's simply wrong that there must be a policy for any exercise of any discretion by any public body. No authority supports that, even ZLL. Lumber, that was a case, as my Lady Justice Laing indicated yesterday, of there being two policies in operation, one which was the lawful policy and the other was the unlawful policy as found, in which the lawful policy, published policy, would not be applied, essentially for the reasons of political expediency. And in the circumstances, it's unsurprising that the deployment of an unpublished policy was found to be contrary to principles of legal certainty in that case. ZLL, we respectfully suggest, does not set a separate standard. The pleaded case, if one looks at it, and this is in Bundle of Authorities 2, tab 21, the pleaded case was at paragraph 4, page 1078. Says halfway down that paragraph, two grounds for judicial review are put forward. One, breach of a public law duty by adopting an unpublished position in non-conformity with published government policy, and then two, breach of a public law duty in not conducting prior consultation. And it was in that context that the duty of prescription is looked at page 1081. And it says it is a recognised feature under subparagraph 4 that there are contexts in which it's legally necessary for public authority powers to be circumscribed by means of the issuing of prescriptive policy guidance. With the greatest respect, Lumber is not authority for that proposition. Now, clearly, if, and we see at the top of page 1082, the word that is used, following B, it is axiomatic, said Lord Justice Sedley, albeit obiter, it is axiomatic in modern government that a lawful policy is necessary if an executive discretion of the significance of the one now under consideration is to be exercised because of the requirement for consistency. And again, with respect, that doesn't find echo in any of the non-obiter observations of a court. So there hasn't been the subject of any ruling from any court at any point. But what that does not establish, we respectfully suggest, is a requirement to have a policy published if in fact you don't have a policy. And that proposition...
Should we look at 34 and 302 of Lumber, because or do we not need to look at it?
Well, 302 was Lord Phillips, who was dissenting, and who
Yeah.
otherwise agreed with Lord Dyson. We can certainly have a look at number. It's in behind tab 10, I think, which is probably in the other bundle of authorities. In Lord Dyson's judgment, paragraph 34 is at page 336. He says there, the rule of law calls for a transparent statement by the executive of the circumstances in which the broad statutory criteria will be exercised. Just as arrest and surveillance powers need to be transparently identified through codes of practice, and immigration powers need to be transparently identified through the immigration rules, so too the immigration detention powers need to be transparently identified through the formulated policy statement. Now that's dealing obviously with a situation in which the Immigration Act mandates the publication of immigration rules, and the immigration rules are then supplemented through internal guidance published by the Home Office. But the finding that's then made in paragraph 35 is the individual has a basic public law right to have his or her case considered under whatever policy the executive sees fit to adopt, provided that the adopted policy is a lawful exercise of the discretion conferred by statute. Now that doesn't say, in my respectful submission, that every discretion conferred on every public authority, which would include the courts, must be accompanied by a policy, and that policy must therefore be published. Because otherwise, this court, when it deals, for example, with costs, would have to have a written statement of the circumstances in which it would deviate from the general position set out in the CPR that costs follow the event, for example.
Can I just ask about paragraph 34? I haven't read number for a few weeks. The rule of law, sorry, the rule of law calls for a transparent statement by the executive of the circumstances in which the broad statutory criteria will be exercised. That seems to be talking about something, a particular set of criteria, not a set of statutory criteria will be exercised. What is the case actually about? What does the broad criteria refer to?
It was about the deportation of foreign prisoners following their conviction for serious offences.
It's about detention, isn't it?
Well, sorry, it was the Hardiel-Singh principles in detention, and one sees paragraph 16, for example, page 331. The vice here was that during the period from April 2006 until September 2008, rather than applying the enforcement instructions and guidance that are dealt with in paragraphs 13 through to 15, as to the circumstances in which detention would be continued, pending removal.
So in other words, it was a policy of blanket detention of FNPs as opposed to the published policy, which was a more nuanced policy about when you detain people.
The published policy was dealing with the Hardiel-Singh principles. So if there's no immediate prospect of the person being removed pursuant to removal directions, then you have to end immigration detention.
Yeah.
As an exception to that, because of a furore in the press, the Home Secretary was saying, well, we're going to carry on detaining them, even if there's no immediate prospect of enforcing the removal directions, because we want them to sit in immigration detention until the fact of removal. And so there was therefore a near blanket ban of applying any discretionary factors that were otherwise set out in a published policy dealing with ending immigration detention, giving effect to the Hardiel-Singh principles set by Mr. Justice Wolfe.
But the prospective deportees are a subset of those who are liable to immigration detention. So there are some people who are in immigration detention who are not about to be deported.
That's true.
Detained
Sorry,
for other
yes.
reasons. So
I've referred to it
everybody.
as foreign national prisoners, but no,
Yeah.
immigration detention is capable of applying to in a variety of situations.
Yeah.
So that was what it was dealing with. It was in the immigration context, and it was in the context of there being a published policy, which was then being ignored in favour of an unpublished policy. And what Lord Dyson was recognising was that where one is exercising the power of detention on broad statutory criteria, and even if one looks at the immigration rules that are adopted pursuant to the Immigration Act, then the Home Office would need to have in place a series of codes and practice which could be transparently identified through the immigration rules to govern the question of immigration detention.
Because I think it's just a power to detain pending deportation or something, isn't it?
It's a very broad power, I think, in the Immigration Act itself.
Yeah.
34, if you read the paragraph immediately before, seems, although it uses the phrase the rule of law, which we all use now every morning at breakfast, I mean, what it actually is referring to, if you read the paragraph before, is a separate point that for Article 5 and for it to be in accordance with law, there has to be something that the European Court of Human Rights recognises as law, which may be statute, which may be guidance, and which has to be of a certain degree of certainty. That's what it seems to be saying, rather than there is a duty at common law, i.e. unconnected with that context, where you must publish, and none of the list of issues of paragraph 10 suggests they were dealing with that, or is that not a right reading of Lumber?
But the issue which is before this court, is there a duty to have a policy in place even if you don't have one for the exercise of a discretion? That issue was not before this court. And in my respectful submission, none of the speeches, none of the judgments of the Supreme Court justices go to that issue. The closest one might get, arguably, is in the dissenting judgment of Lord Phillips. I think it's paragraph 309, page 411. He's dealing with legitimate expectation. Sorry, paragraph 302, page 409. And the highest it goes there is agreeing with Lord Dyson that under principles of public law, it was necessary for the Secretary of State to have policies in relation to the exercise of her powers of decisions of detention of immigrants, and that those policies had to be published. That's the highest it goes. But it's in the very specific context of immigration detention, where there was in any event already a policy. So with the greatest respect, I don't think Lord Phillips was addressing the judicial mind to the question that is before this court.
And although we say a duty means you can get a mandatory order, as I keep saying, here we're talking about the consequences of not having a duty. Here it's clear the consequences are, if you need a policy, you can't detain them without a policy because you don't know whether the criteria are met. But here it's what would be the consequences of refusing the exemption without having a policy on when you should refuse it.
Yes. The sorts of decisions that are being made in this case, in this context, are not ones that call, for legal certainty reasons or any other reason, for the publication of a policy.
What can you remind us what ground for judicial review does our current ground 2 spring from?
Well, a common law duty of fairness is how my
Yes, but I'm just trying to situate within the judgment or within the JR claim the assertion that there had to be a policy.
Starts at page 280, behind tab 13 of the core bundle.
280.
280. My learned friends adopting the Fordham-esque, if I can put it that way, practice of capitalising important terms. And he said that there was, if contrary to the ground 1, there was no discounting discretion. OFWAT has acted unfairly by developing the key criteria as used after the event. That's how it's put.
So that's the way it was put in the claim form, is the later development of criteria, not the absence of a policy to begin with.
Well, I just want to know where does the judge deal with the submission that there ought to have been a policy that it ought to have been published?
In his judgment, I gave my lord the reference. It was
It's 93.
93 to 100.
And he presupposes that, or he may presuppose that the duty of prescription applies, but if it does apply, this case isn't one of them.
Yes. Well, what he says in 97, having set out the observations of Mr. Justice Fordham in ZLL, is the present case is not a case where the duty of prescription applies. I accept that that perhaps implicitly suggests there is a duty of prescription in the first place. The position we've taken consistently on our written submissions is we can't identify a case outside of the convention context, the ECHR context, where it could be said that a duty of prescription arises as a matter of common law. What I mean by that is duty of prescription in circumstances where one doesn't have a policy. You need to have a policy, and if you have a policy, it needs to be in writing. I can understand why, if one has a policy, it should be committed to writing. If there is a policy that exists, it would be hard to think that the policy could exist without being at some point reduced to writing, because otherwise what criteria are people applying? But the core foundational argument here is that every exercise of every discretion by a public body has to be accompanied by a written policy.
Well, I think that's your characterisation of the case, presumably on the basis that if you have to have a policy for this, you'd have to have a policy for everything.
Well, this is a once in the 30-year
Yes,
exercise.
exactly. Well, I think we've got the general gist of this, Grant.
Thank you. Would your lordship and lordship give me a moment? Nobody's tugging metaphorically my judicial gown. My non-judicial gown.
Gosh. So you're going to write the judgment as well, Mr. B. That'll save us a lot of time.
All right. Thank you very much
Thank you
indeed. And, yes.
I'm going to rather boringly take matters in somewhat chronological order
Not
to deal with the points that I think are material as my learned friend raised them. The first point yesterday was that he attempted to substantiate the argument that the guidance is clear from its face by pointing you to two other forms of guidance. Both weren't in fact the product of the UK Water Industry Research Group. They were effectively KPMG following the template set, and that's because, as you recall, the UK WIR addressed three topics: supply interruptions, sewer flooding, and burst mains. And the two guidance documents he took you to were on different topics. So there is, to that extent, a different author. But what he was seeking to do was some kind of compare and contrast exercise, where he said, look at the treatment in those measures, look at the bubble diagrams. That leads you to a position where you can make certain conclusions about the content of this particular reporting guidance. And there are three facets of that argument, I would suggest, that are hugely problematic. Firstly, this wasn't an exercise or an analysis in any way accepted by the judge. Indeed, the judge rejected the utility of compare and contrast with other measures. And he certainly didn't accept any arguments based upon the bubble diagrams, which didn't even feature in my learned friend's skeleton arguments. Secondly, once you appreciate, as I think the court so clearly does, that the bubble diagrams and the reporting guidance are all about what the water company has to do by way of reporting. The clue is in the name. It's reporting guidance. The bubble diagrams merely indicate the steps taken by the companies up to the point of reporting. It's my Lord Justice Lewis's point. The fact, therefore, that there is a bubble diagram containing the word exclusion shows no more than that exclusion is effectively self-policing. Because what it means is, under the structure of the reporting guidance, take the first one in question, the mains water exemption, it shows you that under the structure of that exception, the water company itself can legitimately not report the relevant data because it can apply the exclusion and exclude the data from such exclusions. Now, we're all agreed that whatever else this guidance does, it requires the water companies in these circumstances to report the supply interruptions that are caused by the storm. And that being so, with respect to the bubble diagrams and the obligations of reporting data, tell you nothing whatever about the operation of the second paragraph of the CE exception. Because the relevant question here is how OFWAT, as opposed to the company, must approach the topic raised by the second paragraph. And that rival submissions are ultimately a binary exercise or a discretionary exercise. The bubble diagrams don't help answer that question at all. What does help in our submission is the actual language used in these provisions. And if you go back to the supplementary bundle and turn up page 174, and it was one of the times I couldn't resist jumping up or intervening, and forgive me, when you look at the language of the exclusion, it has exactly the same structure as here. The default position, Mr. Beale's favourite submission, the default position is that water companies manage the risk of mains bursts and there are no exclusions. The cause of the mains burst is not relevant to the calculation of the reported figure. So that's so far identical to paragraph 1 of the C exception, with the following exceptions and points of clarification. And there, the word exception is used again. And once again, and entirely consistently with my submission yesterday, it is used to describe something that is in fact an exclusion. In other words, it's an exception to the rule that there is no exclusion. In other words, a very narrow exclusion.
Exclusion of the obligation to report the data, is it?
In that case, it's an exclusion of the obligation to report the data. Absolutely right. And that's why it appears in the flow diagram. But the forensic point I make is that it's an exception from the default rule that leads ultimately to the data not counting towards the counting for the relevant metric. And we say, following that language and similarity of approach, this provision operates in exactly the same way, but with the difference that that process of excluding the relevant supply interruptions from the calculus is overseen and determined by OFWAT. In other words, it's not self-administered by the companies. So if anything, these provisions in fact assist our interpretation. Now the other thing you get from this is that the topic of weather and how it is treated in the different exceptions gets very different treatment in different contexts. And you see that, in fact, from the other document my learned friend showed you. Because when you look at the exclusions in this context, page 185 of the track changes version, or the equivalent passage in the document my learned friend handed up this morning, you'll see what is dealt with is extreme weather resulting in problems with water quality. And here, there is a fairly nuanced approach adopted in relation to extreme weather. Now, extreme weather is not the same as a civil emergency. You'll remember my submission yesterday that civil emergencies are a subset, a very small subset of extreme weather. And here, a company that adopts the approach permitted from the exclusion from unplanned outages arising from changes in raw water quality, let's say hugely increased turbidity in a reservoir because of a storm or something of that kind, I don't know what the precise example is, then the company is expected to demonstrate, or based on evidence, normal water quality operating bands and record water quality events. So you see that the topic of weather receives a fairly nuanced and different treatment according to its context. And that then feeds into what I wanted to say about Appendix B, because the whole topic of Appendix B, as it was presented yesterday, is a total red herring.
Yes.
It's a total red herring because there was no reservation of the position, as my learned friend described it yesterday, about civil emergency weathers and what might amount to civil emergency for the purposes of the supply interruption metric. The document very clearly shows that the only issue that was parked was how to treat severe weather, which is not even extreme weather, not even a civil emergency, for the purposes not of the supply interruption metric, but the sewer flooding. Now, it helps for you to understand what sewer flooding is.
Well, are you both agreed that this is all a red herring?
I don't know. My learned friend suggested that this supported his argument. If that,
Well, I'm sorry if insofar as he did, it hasn't lodged with me. But it's mightily supported.
He hinted at it yesterday, but I think today when we looked at it, I think he
I think
didn't tie his colours to
went
that
away.
mast.
So
If it's a dead duck, I'll put it in the dead duck pile. It is a dead duck. It's a complete irrelevance. It has nothing whatsoever to do with the knotty issue here, which is what, in fact, is the required response to the second paragraph of the CE exception. And time again, my learned friend repeated his mantra, it's no exclusions, it's a general allocation of risk. None of that is in dispute. What the issue in this case is what is meant by the second paragraph. Because the second paragraph, however you cut it, plainly exists to qualify the effect of the first paragraph. That's the terrain for argument, and referring to the fact that we're clamping down on exclusions and we have a general policy of no exclusions doesn't answer the question, what is the policy, and if necessary by application, the rule that operates in the circumstances that we've decided to mitigate or qualify by the C exception the operation of that rule. That's the relevant terrain for inquiry. Now, before we get to that, can I just address the topic of fault, no fault? I think we're all agreed that whether or not, or what form of fault analysis is required, is either a function of the words on the basis of, or it's a function of the fact that there is a discretion. And my learned friend's very clear concession was, if we're into the terrain of discretion, then fault, and to whom the relevant interruption is attributable, is a relevant consideration. And that's an interesting concession. We'll come back to that in the context of Brown 1b, because when you read the policy document that is the final determination, it's a consideration that nowhere figures in the actual analysis. Literally nowhere. And one can say that of performance in general. How the company performed in the storm, its employees going out into the fray, etc., how they managed to make, nowhere does any of that figure in any way. How they performed in relative terms, how they performed outside the storm. None of that figures in any way. Instead, you have the position very clearly and candidly explained by my learned friend that effectively the only metric for determination in this case was, as my Lord Justice Jackson put it, a macro policy, is the response, is the financial number.
I didn't actually say that. I said that.
I think you said at the very highest level of policy or generality.
Yes.
Something to that effect.
I said, whatever I said, I wasn't suggesting that there was a macro policy.
Well,
I was understanding that the authority had taken a very high level, broad brush, whatever you like to call it, view of all the material that was before it. Now, it wasn't giving a, we decide this for the following 16 reasons.
Yes.
That was what that exchange established.
But what it established, in my respectful submission, is first of all, whatever was done wasn't anchored in any way in performance in the particular circumstances at the time. And secondly, the real consideration, the real driving concern was the delta, was the difference between the inclusion and the exclusion of the events that were caused on a but-for basis by the storm so substantial as within a 1 year period to produce a result outside the commercial expectations of the company. Now that was a logic that was in no way connected to the type of civil emergency. It wasn't said to be that's appropriate for extreme weather, but it wouldn't apply for terrorism or anything else. It was a generic analysis of the appropriate response to the delta produced by the inclusion or exclusion of the events flowing from the civil emergency, any civil emergency.
Yes, it was a generic response which was very considerably in your favour. What you're complaining about is it wasn't even more considerably in your favour.
With respect, that's not all we're complaining about, my Lord, because the very first time that stance, let's call it stance, I don't like the word policy, that stance is revealed, and it is a generic stance that applies across the operation of this particular provision, is in the final determination. The stance that is adopted beforehand is a completely different one, which is you've got all the risk, no exceptions, no discount.
I can't see why this matters. First question for us is it automatic or not? If it's not automatic,
Absolutely
then
right.
you had to do so many supplies and you
Absolutely
didn't.
right. So in
Thereafter,
terms of
you get a discount when you shouldn't have.
in terms of ground 1A and back to the fault, no fault position, the reason I raise this is because my learned friend's home for considerations of fault was in his discretion argument. And he says it's the starting point or a relevant consideration. And it has to be, in our submission, the starting point because clause 12 is all about, condition 12 is all about performance metrics and performance pursuits. I'll come back to that. We say that that consideration is housed in the language on the basis of a civil emergency. And we say that that language is more than sufficient to introduce a test of legal causation. And there's nothing problematic about that. My Lord's objections to that is, isn't that a very complex exercise and doesn't it give rise to a granular investigation? Well, with respect, that's precisely the investigation that's required of every one of the exceptions and exclusions. If you go back to the mains burst, you have to inquire whether or not the mains burst was as a result of a JCB digger for which you can make a claim and there's a prospect of potential recovery. That's the exclusion there. You have to establish the facts of that there's a third party and you could claim against the third party. So the only difference with respect is the party that is in charge of the causation investigations. And we say that party is OFWAT. It makes perfect sense for OFWAT to be in charge of the determination, is there a civil emergency?
Well, I have a sense here, Mr. Dermo, that this is not so much a reply, but I mean, you and Mr. Beale pass each other like ships in the night on this issue, and either we board one ship or the other. In a sense, it's not you're re-urging the points that you urged upon us very effectively beforehand.
I think the point I'm making is that intuitively, instinctively, you do have to find a home for considerations of fault. It would be very strange if at the end of this process, the process was one that was blind to the responsibility of the water company for the events in question. And that's why, from the outset...
That all depends on what the words mean.
That's true, but the words generally have to mean or generate a sense that makes sense, and a system in which there is no place to take account of the fact that massive problems are caused by terrible inadequacies of a contingency plan doesn't seem to make a great deal of sense for a regime that's all about...
If a JCB cuts the thing off and it's somebody else on a rogue mission, it's still not your fault and you still pay. It's all a question of scale.
But that's because the level of fault there is connected to the time in which you're expected to respond. That's the point. The reason the metric is set from 3 hours is you're meant to be able to respond to those events. That's the point, and that's the fault that is directed by the measure in question. So, we have to find a place for considerations of fault. So we're down to binary versus relieving discretion. And that then takes us to the submissions on ground 1A. Now, I think my learned friend has maintained his position that there's plain language supports his case. We say the judge is right. This is an opaque provision. I won't repeat my submissions in relation to that. What was more interesting was his attempted response to what we said was the most important consideration here, which is what the regulatory scheme tells you. Now, the relevance of the allocation of appeal rights, the relevance of that lies in what the regulatory scheme tells you about when and where and how you make decisions that have wide-ranging policy implications or are capable of dispute on the plane of policy. And the regulatory scheme tells you that those decisions should be located at the 5-yearly decisions in a way capable of challenge at that point. And the vice, and this was accepted by the judge as a point in our favour, of the identification of the discretion at issue here is that it puts off the identification of the particular policy to the point of final determination. And there's no getting away from the fact that the position Mr. Beale described that was finally adopted, which was, is the swing sufficiently large in a 1 year period to take you outside the envelope, is precisely the type of policy decision that the CMA grapples with, because it has nothing to do with the facts of the case. It's a rubric capable of general and universal application, as I was explaining, to all types of civil emergency. And that's why the judge at 88 to 89 was quite right to accept that the structure of appeal and judicial review and the nature of the issues thrown up by the discretion in this case was a strong pointer against the existence of discretion, one he felt outweighed by other factors. And what Mr. Beale said this morning about the reasons for not adopting an appeal on the merits in relation to the PCs is further revelatory, because his submission was the reason that it was decided not to provide the CMA appeals in relation to price performance commitment decisions and the impact that they will have under Part 3A is because the sorts of change that they produce, the minor changes they produce, are not sufficient to justify supervision by the CMA. That was his submission. And that rather runs into what the actual eventual position they've taken is, which is because civil emergencies can produce swings in the number so large because of their asymmetric effect and because of their effect in distorting the metrics, because of their asymmetric downside risk, for that reason we have to protect the envelope. In other words, the swings are so large that would otherwise be produced that we have to mitigate them. In other words, it's exactly the type of issue we'd expect to go to the CMA. And that's why we say the policy finally alighted upon in fact substantiates our position and our position in relation to appeal rights. That was the first string of the regulatory appeal. Nothing my learned friend said answered that point. He sought to say, well, it's all inconsistent with what the judge found about Mr. Beaver's evidence. But that's a red herring in respect. It's a red herring because the judge didn't take any of that into account when saying, as a question of construction, and that is the relevant issue, as a question of construction, the allocation of appeal and judicial review weighs against reading it as incorporating a discretion. That point's good or bad, whatever Mr. Beaver thought at the time, it's completely irrelevant to whether or not an appeal right and its contours is an aid to construction as to the width of the discretion conferred by a section set in advance. So I'm afraid the light on the jury box my learned friend had referred to earlier came back on at that stage because it's forensically irrelevant to the utility of this as a point of construction. Then we come on to condition B12. And here I think our position is precisely as my Lord Justice Jackson identified and as somewhat mischaracterised by my learned friend. Our position is that when you read condition B12, its plain focus is upon incentivising performance by reference to certain metrics and providing rewards or in substance penalties depending upon how you do according to those metrics. Indeed, and it was a point I made yesterday which wasn't answered, it's a point that flows from the very definition given at page 365, 12.8 of performance commitment. Because performance commitment means a target or other measure of performance of the appointee in relation to the carrying out of the activity. So it's all about targets or measures of performance that then bring with them financial consequences. And our point is, very simply, that being the focal point, incentivising performance, is a strong pointer towards the continuation of the sort of binary in-out of the data approach that is adopted across all of the metrics. Why? Because the decision to include or exclude is ultimately about including or excluding data that doesn't meaningfully reveal anything about the actual performance of the relevant company. And that's why we come back to what is the purpose of the second limb of the CE exception. We say the second limb can only have one identifiable purpose, which is to reflect the fact that in circumstances where companies' resilience is only funded up to a certain point, that it makes no sense at all, given the underlying UK water industry objectives, also OFWAT's objectives, you've seen the consistency, comparability, etc. It makes no sense at all to include in that measure of performance things that are wholly outside and incapable of response by way of the water companies, because that's not a measure of their performance, that's a measure of their bad luck. And the whole point is you're meant to be assessing things that they are capable of controlling, including third-party fault. That's something that they're capable of mitigating. That's something that the performance metrics are directed at. But no one can realistically be expected to control for all the adverse effects for truly extreme civil emergencies. Now, my learned friend said yesterday, well, if that's the effect, that would be very, very strange. Would be a strange allocation of risk to put that back on the customer. And I have to say, with respect, I found that to be a bizarre submission, because that's exactly what force majeure does in the context of contract. In any performance-based contract, it is usual to see the party promising performance to accept certain situations in which they can't perform for events wholly outside their control. And all that the second limb of conditions of the CE exception is a very narrowly formulated force majeure clause, effectively, under the control of OFWAT. That's what it is, that's what its function is, that's what its purpose is. And once you understand it in that way, it makes absolute sense that once its conditions are met, once the test of the CE exception and legal causation is met, it operates in a binary fashion. And with respect, that was the issue with which my learned friend nearly, in no way, actually engaged. He never actually engaged with what is the purpose of the second paragraph. And that's the critical question in this case. That then also feeds in with respect to my Lord Justice Jackson's questions about consumers. And it also feeds into his submissions that we never made any submissions about performance. We did make submissions about performance. I invite you to read our representations. Their structure is very clear. Their structure is, this is how we in fact performed. This is where we failed, the 3.375 million to be taken out of account because our backups didn't work and they should have worked, etc. And these are the consequences that will occur if you take...
But we're back here to the point I made about passing ships, that this is the epitome of that situation where you presented according to one theory of what should be happening, and they responded in accordance to a completely different theory of what should be happening. So, in a sense, I'm not sure what's gained from their failure to respond to your point, because either they're wrong and they should have done.
I think a different point was made by my other friend. He said we addressed in our submission topics going beyond performance, like the allocation of risk. And the point I was going to make is, having set out what we said the correct approach was by reference to performance, the submission went on to explain that if you took into account these wider considerations, you would be reallocating risk. And that's what was done. Effectively, the submission said the proper focus is performance and anything else is reallocation of risk. So I encourage you to read the submissions because they don't have the character that my learned friend says. One thing that is important to understand, given my Lord's concerns about consumers, is that we were careful to ask our consumers what they thought about this. this. And if you read Mr. Beaver's evidence, his first witness statement, sections L, M and N, you will see that the consumers who were affected by the storm, part of the submission was they were canvassed about how they felt we had performed, and we analysed whether the customer measure of experience, in other words, customer satisfaction, had changed in consequence of the storm.
But how can that even remotely be relevant to working out what the words mean?
It's a point I'm simply making. I agree with that, my lord, but it's a point I'm simply making to make the point that the submission that we presented was directed at performance to answer the contention that it wasn't. And one of the things we said is, look, our customers think we performed, and they have no problem with what happened in this truly exceptional circumstance. So we don't accept that the representations weren't about performance in any event. So condition B12, we say, once you understand that it's about performance writ large rather than the default outcome under the particular metric, is a tell in our submission against the sort of discretion that was contended for, a discretion which is unbounded by performance. Then there were some submissions on efficiency. With respect, my learned friend didn't answer the very simple point I made. We accept the judge found that there was no risk of inefficiency inherent in the rule. He did find, and his passage was very clear, that there was a risk of such. And my point was simply that once there's a risk of inefficiency, that too is a factor pointing against the interpretation in question. Then condition B14 and B15 were adverted to. My learned friend accepted that whether it was an upwards change sought by the company or a downwards change sought by OFWAT under condition 15, all of that went to the CMA. I think, though he didn't say, it's also common ground that the changes in question would all be prospective. And he said, none of that bites upon Part 3A matters because they're all thought to be immaterial. And again, the problem with that is it runs into the same answer I gave on the plane of policy. Once you accept that the policy being adopted here is not to make any change that has a certain high level of materiality, you can see that what's really happening is that this condition is being used to effectively circumvent or rewrite conditions B14 and 15. And we say that too is in fact a pointer against there being any such discretion and the rule instead operating on the plane of automaticity. Short point about the attitude of other regulators. We didn't say anything beyond this. I was very careful. I said the different position of other regulators who took the kind of bright lines that we advocate in our case shows that the relevant rules in question can't be, as the judge characterised it, absurd. That was the only point I made. Whether or not Ofgem are subsequently deciding to change that rule and to move within different regulatory responses is irrelevant. One of the judge's key objections to our construction was that objection of absurdity. And if that objection had any merit at all, it would follow that the old rules, let's assume they are old rules of Ofgem, and the other regulators who adopt a different approach would be similarly absurd. Then it was said that there is no uncertainty here. And it was said, well, this is a 1 in 30-year event. What are you complaining about? Rare as hen's teeth and all of that. The problem is that that argument doesn't address the following things. It doesn't address the fact that we don't get any certainty at all as to the approach that is going to be adopted. In other words, the target we even have to aim at until the final determination, because it's only the final determination that effectively reveals for the first time, and that has never been the subject of any submission, the rule or policy that is in fact adopted, the envelope and the single years policy. There was no indication that that was their stance. None at all.
Their stance is their conclusion.
Well,
It's what they arrive at having looked at the representations. It's not what they started off with, it's what they ended up with. They changed their mind.
But that's absolutely right. It's their conclusion, but it's their conclusion based upon axiomatic reasoning, which would have been perfectly capable of being set in advance and disclosed in advance in the subject of argument. We've never had, until this case, an opportunity to have that argument. And that's part and parcel of the vice, that effectively it is a policy decision, and the policy decision only becomes apparent at the end. The second problem is that once that rule is adopted, it sends a signal to everyone. Because everyone is surely entitled to the same consistent treatment with that rule when they next present with their civil emergency, whether it's extreme weather or terrorism or whatever. That's going to be the approach, surely, that has to be adopted in the resolution of their case. So anyone making investment decisions in this space is now going to know that, in effect, there is a de facto cap on the amount that they can be charged under this particular provision, and that cap is effectively set by the one-year envelopes, because that's where we've arrived at. The justification is a kind of soft cap on the amount that this can generate. And knowledge of that soft cap is obviously going to inform the decisions that other companies make, as well as my client, on questions like resilience. So that's the problem. It's not enough to say, well, the event is 1 in 30 years, ergo it's not a problem. Every year, companies make decisions about how much to spend on resilience. That's part of the parcel of the matrix of their difficult decisions as to how they prioritise spending between the different performance commitments. The fact that the risk for which they spend the money may only materialise 1 in 30 years doesn't mean that it doesn't play an important part in their everyday financial decision making or their business strategy. And that's why there is uncertainty. That's why the introduction of the discretion does generate uncertainty. It makes the rules of the game after the event.
We've got this point.
Ground 1B, I think we've come down to a very condensed position. Once you understand that our case is that performance for ground 1B isn't the performance under the metric in question, because that then turns the whole issue into an empty vessel. It is performance by reference to the topic of supply interruption, how we are generally performing in supply interruption, back to the policy that must be inherent in the second paragraph, stripped of the distorting effect of the storm. So in other words, performance controlled for the storm. Because otherwise, every year you're going to have an asterisk in the metric, because you're going to say these figures are completely unrepresentative because they've been fundamentally distorted by the storm. Once you understand that and the overarching objectives of consistency of reporting and comparability between companies, the whole purpose here is to strip out those features of the exceptional weather event that lead to exceptional downturns in performance that make the relevant event non-comparable and non-meaningful. And that's not tied into the first paragraph of the C exception, it's performance writ large, as I made clear yesterday. And that's why we say that topic of performance is akin to a Padfield purpose. How do I then answer the section 2 point? Well, if we're right that the sole and overarching consideration for the second limb is the stripping out of unrepresentative or non-comparable or truly exceptional weather event related performance, that is the purpose at that stage. It means then that if there is any section 2 exercise to be performed for each and every performance commitment at the section 12.5 stage, then this exercise is no different to the exercise in relation to a performance commitment in which the metric is produced without that exercise of stripping out the unrepresentative data. In other words, it's already occurred. And that must mean that it would be a truly exceptional circumstance in which the PC having determined the amount in question that should be calculated, would have that number rewritten by reference to general concerns like resilience, ability to carry out their function, etc. Because I think certainly the tenor of the questioning from my Lord Justice Jackson yesterday is we are all agreed that in general any attempt to rewrite the numbers produced by the performance commitment would be truly exceptional. And the reason for that is they are the bargain. They are the performance promised for the reward offered. That's effectively what the position here is. It is the regulatory equivalent of a contract. And if you're going to rewrite the rules of the contract, then it would have to be truly exceptional to do so. And we're into the realms of substantive legitimate expectation. So my answer is Padfield operates on the second limb of the CE exception. It confines the purpose for which that exercise may be undertaken. It tells you what the type of performance is that's relevant and not relevant, what the types of considerations are. And if Section 2 has a role, once that function has been discharged under the CE exception, and you've got your answer in the metric, then Section 2 works on the number that is generated by the proper application of that performance commitment in the same way as it works on any other performance commitment. It would have to be truly exceptional to step outside the number produced in those circumstances. That's what we say about ground 1B. It was said that we said somehow it would be truly shocking if Section 2 came in conjunction with discretion. That's not, with respect, what we said. It's not what we've ever said. We said it would be truly shocking if Section 2 could be reused on anything other than a truly exceptional basis to rewrite the bargains struck by the performance commitments. And that is a submission from which I in no way retreat. Ground 2. There is a straw man in my learned friend's argument. Put aside the argument about what the law actually is. What are we actually arguing? Are we arguing that any discretion, once it's identified as it exists, axiomatically triggers an obligation to adopt a policy? No, we're not. Our arguments have always been anchored in context. Go back and look at our grounds.
Well, I don't think we need to do that. We perfectly understand that your headline submission is not that every discretion requires a policy. We perfectly understand that. What is being said against you is that if this discretion requires a policy, then it's hard to think of one that doesn't.
Well, that is an obviously bad submission, because the facts of this case are extremely unusual for the reasons I identified yesterday and that haven't been addressed. This is a scheme designed to incentivise financial performance.
But I think,
that's the context.
To be honest, in relation to ground 2, it's a really small point, this. I mean, I appreciate that what we make of the obiter statements in other cases is a matter that we need to deal with. But, I mean, as to whether or not we think there ought to have been a policy, having listened for a day and a half to what's going on here, we're quite able to reach a conclusion about it. And in a sense, I don't invite you to repeat arguments.
I'm not going to repeat the argument. I'm just simply saying, and you have the point, our argument wasn't the one that's been characterised.
Yes.
It's a very narrow one that says in this very special context, a duty arises, because that's what fairness requires. Otherwise,
you need to have no apprehension that we were misled.
I'm grateful.
Cases.
I'm grateful. So I probably need to say a little bit about Lumber, because you went to Lumber.
Thank you.
And then I'll culminate on that. It's true that Lumber is directed at a situation where there was a policy and there was a secret policy. But if you look at what Lord Dyson says at 34 and 35, it is, on its face, containing of general propositions. I take my Lord Justice Lewis's point that we should be careful about easy invocations or generalised invocations about the rule of law. But what he said at 35 is that the individual has a basic, not convention, right?
tab?
Page tab 10, page 336. Has the basic public law right, not convention right, public law, to have his or her case considered under whichever policy is in force. That's in Ray Findlay.
Which paragraph? I'm so sorry.
35.
Right, okay.
So this is all general public law. In Ray Findlay is a pre-Human Rights Act case, prisoner's case. And then there's a correlative right to know what that current existing policy is so that the individual can make relevant representations as to it. And this identifies what we call the dual needs. And the point we make is simply this. What Lumber says about the obligation to publish is also informative on the plane of principle in working out those cases in which the context requires the adoption of a policy to control a widely formulated discretion. So one feature that is particularly important, and it's a feature picked up obiter by Lord Justice Sedley in B, is the width of the discretion and the large numbers of people affected. Another context is the importance of consistency of decision making. Those are simply two indicators of context that point towards the potential requirement for a policy. And we say, and we've always been explicit about this, there is no case that grapples with a public law de facto contract or scheme of incentive payments. We say that that factor, on the facts of this case, produces similar needs, because if you're going to determine how much a party gets paid and what performance is expected them to give in order to obtain such payment, we say it's a basic and obvious legal proposition, readily understandable by a man in the street, that you tell them that in advance, in sufficient detail. And that's why it's an axiomatic, unfair contractual term to vary the expected performance at the discretion of one party after the fact of contracting. It's the same common sense rules. No case on it, but you don't need to have a case to identify an obvious point of principle. It's those factors that make this context one in which a policy has to be adopted. Now, in answer to my learned Lord Justice Lewis's question, what's the effect of that? I said it's an unfairness because we're never told it in advance. The second level effect is it's still unfair because we weren't told of the relevant policy even until the final determination. So the less intense response that you can adopt is to say it's unfair that you didn't tell them in advance that this is the target that they have to aim at, the envelope target, and to allow them to make submissions of that before you reach the final decision.
So what remedy do you seek? A quashing order of the final determination and a remittal back so you can make a further representation on the final determination?
That would be the alternative. I stand by my primary case, which is, as I explained yesterday, because the policy...
Reinterpret or discretion, or if that fails, quash and remit.
That's right. So those are my submissions. I finished just before.
Thank you very much indeed, Mr. Grateful. Well, can we express our thanks to not only the advocates, but those who have not spoken and those who've done all the work behind the scenes. We thank you all very much indeed for the help that you've given us. It's an interesting appeal, and we'll take time to consider our judgments. As you'll be aware, you'll receive the judgments in draft, in confidence, only to those who are listed to be able to see them, and we'll be grateful, please, for any assistance with editorial corrections only, and also a draft order reflecting the decision that we will come to, and in due course we'll then hand down those judgments electronically and publicly. We won't trouble you to return for that purpose. Thank you all again.